People who consult us often ask, how much maintenance will I have to pay my spouse, or how much maintenance am I entitled to? Those are good questions, and the answer is somewhat complex. In Illinois, entitlement to maintenance is governed by a two-step process. Many people assume that a couple who has been married for a lengthy period of time will have a divorce in which maintenance is paid, but that is not necessarily the case. In Illinois, the court initially makes a threshold determination as to whether a recipient is indeed entitled to maintenance. That process involves the court's consideration of about 14 or 15 factors. These include the incomes of the parties, their occupations, their health or lack of good health, the amount of time, for example, that one of the spouses has spent delaying education or career in order to support the other spouse's advancement in career. There are a variety of statutory factors that the court considers. After weighing the evidence that is presented on those factors, the court makes a determination as to whether maintenance is appropriate for that particular situation. If the court decides that maintenance is not appropriate, the court will enter an order barring maintenance, and that's a forever bar of maintenance. On the other hand, if the evidence shows that indeed this is a case where maintenance is appropriate to be paid from one client to the other, then the second part of the two-step process kicks in. Our Illinois statute has a guideline for the calculation as to the amount of maintenance to be paid. The amount of maintenance pursuant to the guideline in the statute applies to couples whose combined gross incomes are $500,000 or less. The statute has a formula which we don't need to get into for the purposes of this answer, but suffice it to say that if the court determines that maintenance is appropriate in the first analysis, the second analysis or the second step kicks in, and there is a formula in place which will determine the amount of maintenance to be paid. There is an exception. In some circumstances, the court can deviate from that, but typically the courts do not. The duration or the amount of time that maintenance will be paid is again subject to the statutory formula. It's based with reference to the length of the marriage in each particular case. And that's an overview of maintenance in Illinois.